Okay, the obvious question is, why the twilight zone? Well, we're going to talk about stopping compensation in a claim. Is there anything else more out in space than that? So what we're going to do is we're going to talk about, can a claim actually go into the twilight zone and never come back? Well, the answer is actually yes, it can. The question is how? And to do that, we have to talk about two different concepts, actually three. The first is continuing jurisdiction of the Industrial Commission. And the second is the good old, like a song, return to baseline or return to sender. And the third is, of course, substantial aggravation, because the standard is based on that. Continuing jurisdiction. That's contained in Ohio Revised Code 4123.52. And that's what gives the Commission jurisdiction to pay bills, to modify things in a claim, to do what they do. That's the statutory provision. Some of the specifics in it are that under Ohio law, in this provision, a claim exists for 5 years. Now, that doesn't sound so bad, does it? You know, 5 years, I mean, you blink and 5 years goes by. Well, the problem with it is that if you pay a medical bill, you pay compensation, you do anything, you get another 5 years. Now think about this. If you're a claimant's lawyer or someone else, they all are well aware of this concept. So, what does that mean to you? Well, when you grant a consult, you pay a doctor's visit, a permanent partial disability award of 1% gets made. What's the result of that? The claim lasts for another 5 years. So, what you need to do is you need to be very much aware of where these claims are in the sequence. And, you know, oftentimes if you have a claim that's been dormant for 4 years and 10 months and now you want to go see the doctor, what's the word that you say? No. Now, you may spend money on a hearing for that. You may lose. You may win. But if you don't, you bought it for another 5 years, so you need to do that. Now, the good news with continuing jurisdiction is if this claim does come up, and it comes up a lot in the context of, say, chiropractic treatment. Somebody's been going to the chiropractor for 4 years, and they haven't submitted the bills to you. And I imagine some of you have had that scenario. And the claim is going to be statutorily dead, so all of a sudden these bills get submitted. They can award only 2 years back. They can't go back and say you're going to pay the whole 4 years, excuse me. So the bottom line here is there is a 2-year limit on how far back you can go, but please, I would suggest that all of you that you have your claims marked for 5 years, because that's an important date on these. So be very, very aware, if you're a self-insured employer in particular, about when they pay. And with the Bureau, you can be an advocate too if you're a state fund employer. I mean, they're your claims. Now, the Bureau administers them, but you can object to them doing various things, and sometimes you really may want to do that because the claim will be around. It may go off your experience, and there's a lot of different factors that someone can talk to you about, but be cognizant of where the claims are. Return to baseline. What this is, it's a provision of the law that was put into place in 2006 and frankly has been underutilized and ignored. And that's not nice to do, because this is something that can help you tremendously. What it says is if you have a condition or you sustain an injury which was substantially aggravated, and we'll talk about what that is in a minute, and it's documented by all these wonderful things, objective findings, objective clinical tests, all the things you need, and that condition gets worse, and it gets back to where it would have been anyway, you are no longer responsible for paying for that condition. Again, if that happens, you are no longer responsible for paying for that condition. Now, why do very few people do this? Well, one, we oftentimes don't ask our doctors those questions, and we don't think of the claims in that light because claims seem to go on forever. This is a tool that we have been using recently. We've used it 2 or 3 times in the administrative process. And guess what? We've shut down the claims. Think about it. If you return to the baseline, when that person files the motion, and Janelle's going to talk about this a little bit later, for a psych condition, the law says the physical condition must cause a psychological condition. If it's back where it was, can it do that? Not by the way I look at the world. I'm not sure that Dave McGill would agree with me, but it clearly is an argument. So it also would bar permanent partial. If you're back to where you were, how do you have any permanent disability if you've returned to your baseline? So there's lots of issues here. Treatment, all those things. Maybe a basis to shut your claim down under the 5-year continuing jurisdiction. So it's something you really, really need to look at. As we go through this, though, to understand when this comes up and how we physically do it, and I'm going to apply it then to Florence here in a little bit, you need to understand substantial aggravation. Substantial aggravation has also been around since 2006. It's used quite a bit. It's misunderstood by a lot of people, I think, also. And it is quite aggravating in the way it is applied. But basically what this says is if you have a pre-existing condition and it gets worse, you have to have some form of objective evidence to substantiate why it's worse. That could be clinical findings. It could be diagnostic tests in the form of an MRI. It can be all those things that are objective, that we can see, feel, and touch. Subjective complaints by themselves are not supposed to be enough. That means the fact that I hurt more than I hurt before doesn't cut the day. However, as we'll talk about in a minute, that's up to a hearing officer to decide, but you need clinical objective findings to have a substantial aggravation. And the reason we're talking about that is we're going to apply that to the return to baseline here in a second. Well, as you can see, we're back in space looking at all this stuff and saying, well, what does it all mean? It's 10 years. It's been 10 years since we started with substantial aggravation. Think about that. That's a long time. I had dark hair 10 years ago. And I can't blame my gray hair on substantial aggravation either. But anyway, the Industrial Commission has attempted to address this a couple times. In front of you is, I think it's Memo 5, I believe. It was decided in, or it was issued in 2008. And what this does is it gives you the standard that they're supposed to apply when dealing with substantial aggravation. The highlighted portion in front of you says it's necessary for them to rely on evidence, but this is a medical, not legal determination. Is there anybody in the room here that can explain that to me? How is it a medical determination? Everything you look at is medical. The MRIs, the office notes, the prior x-rays, all of those things, they're all medical. So what are you doing? You're giving the hearing officer or the lawyer a medical degree. And I'm going to tell you, there's not too many lawyers that I want to treat me medically or make decisions medically for me. And that's what we are doing. It is the law. The hearing officers can make a legal determination based on the medical evidence. You don't need magic words. They can look at us and they can tell us what it all means. Sort of like a politician, you know. I hear one thing and they tell us another, but now they're going to tell us all what it means. That's the way it works. So it is a medical determination that they will make. We also have a policy memo, S11, that talks about how you prove these things. And this is another thing that doesn't make much sense to me. I may not be the brightest tool in the shed, but I'm not the dullest either. But what this says is that we can have different types of causation that can be addressed. There is direct cause, I bend over, I hurt my back, or substantial aggravation. But doesn't it sort of make sense that you'd have one or the other? I mean, isn't it inconsistent if I'm saying, I bent over, I hurt it? No, I bent over and I substantially aggravated it? Well, in the legal sense, it's called arguing in the alternative. But what this allows the commission to do is address both in an order. Now, if you happen to be at a hearing and all of a sudden you get sandbagged with a different theory of causation, you can request a continuance and get medical on it. Because the game is, if I have an examination scheduled with Dr. X, and they're alleging that this activity caused this condition, what am I typically going to ask the doctor? Did that activity cause that condition, right? I get to the hearing, and I get medical evidence that says, oh, well, we're here on a substantial aggravation theory. I don't have any medical on or substantial aggravation because I didn't ask the question. And the argument from opposing counsel is, well, there's no contrary medical, hence I have to win. No, you can request a continuance. And frankly, what I do 9 times out of 10 is when I have an IME, I ask doctors both questions to avoid this particular issue, which seems to be coming up. The other theory on this that you need to be aware of that's really common now that ties into this is flow-through. The law does not provide for specific flow-through injuries. The law says you can have an injury caused or you can have an injury that's substantially aggravated. What's this flow-through stuff? It flows from the injury. And hearing officers, some claims are allowed on that basis. But the reality of it is, why are they doing it? Well, they don't have evidence on direct cause. The doctor won't give them substantial aggravation, so they're going to say, well, it flows through my altered gait. It flows through this. And as you'll see, especially coming out of the Columbus area, this is a common tactic that's being used. It's not used quite as much in the Toledo area, but Columbus and south, we're seeing that a lot. It's almost where, that's almost always the theory of causation. So if you have that, you've got to address that also. So what's all this mean? To get back to our fact pattern here. Something significant has to happen. Of considerable degree, it has to get worse, can't get better. That's not a substantial aggravation. You have to have objective evidence, and then if you have that, you have substantial aggravation. How does the commission look at this? Not the same way I do. What they do is, and this is basically the same type of situation here, they say that they need to have objective evidence supporting it. Look at your orders. If the orders do not have that, then there's a problem. A lot of the orders do not have evidence of objective evidence of substantial aggravation. It should be in the order. It's a legal determination, as I pontificated on before, and you also do not necessarily have to have a medical, or do not have to have specific medical evidence to say substantial aggravation. The hearing officer can go to the cloud, think about it, and decide that it's a substantial aggravation. So that's what the standards are, and that's what the commission does. You don't need magic words or anything else. It doesn't have to say just a substantial aggravation. The hearing officer can make that conclusion based on the evidence in front of them. So, legal determination, magic word, objective evidence, pre-existing diagnostic studies, and subjective complaints with objective findings. That's what we're talking about here. And I think these 2 slides are a good summary of where we are. Now, how's this apply? I don't like her calling her Florence. I like Flo. Because I actually hate these commercials. This lady drives me nuts. But I think it works. People like Florence. So what's the deal with Flo here? Well, Flo's the traveling nurse. She injured her back. She had a history of chronic back pain before all this. And her claim was allowed for, and we're going to talk about these in a second here, a low back strain, substantial aggravation of pre-existing degenerative disc disease at 045, and substantial aggravation of pre-existing generalized anxiety disorder. They did an MRI on her in 2014, which was before. It showed the degenerative disc disease, so it was there. In May of 2015, they did another one, and it was there, and they said it was advanced compared to the one in 2004. So there would be evidence in this scenario of substantial aggravation. Well, of course, if we're going to have a case like this, we need to have some chiropractic care in it also, don't we? I mean, why not? Well, before the injury, she was going 1 time a week. After the injury, she was going 3 times a week. She obviously did not go to the Rob School King of Rehab here. And I'm not his father, by the way, anybody. We have an IME that says the chiropractic treatment is no longer relevant. Now, what's the law say about this? If a condition pre-existed and the substantial aggravation occurred, once that condition has returned to a level that existed without the injury, that wonderful word again, no compensation or benefits are payable because of the pre-existing condition. That's good stuff, people. Now, how do you get there? That's the question. That's the tricky part. But if you get there, you are in a position where this claim can be over. So my question is, how do we get back to where we would have been anywhere? And that's supposed to be Back to the Future, the car, but I think it sort of looks like it. Well, you can always ask the attending physician. Good luck with that, but you can do that, and you should do that. And if you have nurse case management, you clearly should have your case manager look at that, but that's not real likely to get that answer from a doctor unless it's someone that doesn't do workers' compensation very much, or they're really mad at the claimant, which does happen too. Obviously, you can look at all the medical records, both before and after the injury, the diagnostic tests before and after the injury, if there's surgery records, what's the work history, return to work, what was the work history before, compare all those things. Surveillance is sometimes good in this also. And then, most likely, what you need is an IME. But when you do the IME, you got to ask this question. Have they returned to the baseline that existed before? If you get the right answer, what do? You file a motion requesting that the commission make a finding that the claimant has returned to the baseline and terminate the activity in the claim. We've done it, I think, 3 times now that we've been successful, and that's a new thing. What about the low back strain? Because I think this is real interesting. I'm up here telling you about substantial aggravation and how to deal with the conditions that are allowed on substantial aggravation. Well, in Flo's case, remember, she had a claim that was also allowed for low back strain. So if I say I want to shut all this stuff down so you can't allege that something else resulted from it or the claim's dead, I still have an underlying strain that's allowed by direct cause in this case, don't I? So what do you do about that? How do you handle that part of it? Well, I think what you try to do on that is you have your physician address that issue also and try to have that person say, look, that was the initial symptom, but that has now resolved. If you have a finding that condition has resolved, and then you have a finding that they've returned to baseline based on the pre-existing condition, I think you have a very good argument to shut the whole claim down. I guess I said that here. Okay, you do all this. And let's take the happy scenario and say that you win. What happens? Well, you win, the claim shut down, but the other side has the right to appeal. They can appeal to court. But what kind of court? If you lose, you can do the same thing, and I would highly recommend you consider it. We have essentially, and there's a talk this afternoon about mandamus actions and some other things, the differences in how you do it, but a mandamus action is in the Court of Appeals, and it's a standard of review basically to see whether the Industrial Commission, in my words, has any evidence supporting what they did. It's called the sum evidence rule. Or you have an appeal or a basis to go to court, to the trial court. This issue has not been decided, but I think the collective view of our office, and I feel strongly on this, is these type of issues are appealable to common pleas court because it goes to the ultimate right to participate in the benefits of the Ohio Workers' Compensation law. A mandamus action usually deals with extent of disability. So this action would be appealable to a court. So here you can maybe go down to Lucas County or the Defiance Courthouse, or I'm not sure, is that Bowling Green, I think is the other one there, but you know, whatever county you are where the injury occurs, you have the ability to go to court on those type of cases. Now, get ready for it, this is good. I hope anyway. Why do you want to do this? Why? Because if you do it, you blow up the claim. It's over. So that's your opportunity here. You want to blow up the claim. You want to be done. Utilize 4123.54 of the Ohio Revised Code. It's there. It was written to be used. And unfortunately, it has not been used much in this state. Thank you.